Hello student, my name is Bharti. I welcome you to all in our first animated lecture of law. In this video you shall read about the Chapter 3, Prospectus and Allotment of Securities, which contains section from 23 to section 42. I hope you liked it.
Section 23 contained the mode of public offer and private placement. It states that a public company can issue security in the following four ways. First, by issuing prospectus. Secondly, through private placement. Third, through right issue. And last, through bonus issue. On the other hand, a private company can issue securities in the following three ways. First, through private placement. Secondly, through bonus issue. Third, through right issue. A private company cannot issue prospectus or cannot invite public to subscribe its security, as it is restricted under Section 2 subsection 68. Is everything clear? Yes, sir. In this section we shall talk about the meaning of prospectus and matter to be stated in prospectus. According to Section 2 subsection 70, prospectus is like a notice, circular, advertisement or any document inviting offer from the public for the subscription or purchase of any security of body corporate, or you can say that prospectus is a document which invite the public to subscribe securities of public company. It include red herring prospectus referred in Section 32, or shelf prospectus referred in Section 31. Now let's talk about the matter contained in prospectus. According to Section 26, every prospectus issued on behalf of a public company, or by any person who has been engaged or interested in the formation of a public company, shall be dated and signed, and shall state such information and set out such reports which may specified by Security Exchange Board in consultation with the central government, provided that until the Security and Exchange Board specifies the information and report on financial information. Under this section, the regulation made by Security and Exchange Board, under the Securities and Exchange Board of India Act, 1992 in respect of such financial information or report on financial information, shall apply, provided also that there are certain exceptions, where the need for issuing prospectus shall not apply. First, where the company issues share to its existing shareholders, and secondly, where the company issues share at same price and of same class as issued before. Also, no prospectus shall be issued on behalf of a company unless on or before the date of its publication, a copy of the prospectus signed by every person who is named therein as a director delivered to registrar, and no prospectus shall be valid if it is issued more than 90 days after the date on which a copy thereof delivered to registrar. Also the registrar shall not register a prospectus unless the requirements of this section with respect to its registration are complied with and the prospectus is accompanied by the consent, in writing of all the persons named in the prospectus. Sir, what if company defaults? If company defaults in complying the provisions of Section 26, then the company will liable for penalty of not less than 50,000, but which may extend to 3 lakhs, and every officer who is in default will liable for a punishment, with a fine of not less than 50,000, but which may extend to 3 lakhs, or imprisonment up to 3 years, or both. A company shall not, at any time, vary the terms of a contract, for which the prospectus was issued, except subject to the approval given by the company in general meeting by way of special resolution, provided that the details of the notice in respect of such resolution to shareholders shall also be published in the newspapers, one in English and one in vernacular language, in the city where the registered office of the company is situated, indicating clearly the justification for such variation, provided further that such company shall not use any amount raised by it through prospectus for buying, trading, or otherwise dealing in equity shares of any other listed company. Also, the dissenting shareholders, being those shareholders who have not agreed to the proposal referred to in the prospectus, shall be given an exit offer by promoters at such exit price, and in such manner and conditions, as may be specified by the Securities and Exchange Board, by making regulations in this behalf. Where certain members of a company propose, in consultation with the board of directors, to offer whole or part of their holding of shares to the public, they may do so, in accordance with such procedure as may be prescribed. Any document by which the offer of sale to the public is made shall be deemed to be a prospectus issued by the company, and all laws and rules made thorough as to the contents of the prospectus, and, liability in respect of misstatements, or omission from prospectus, or otherwise relating to prospectus, shall apply as if this is a prospectus issued by the company. The members, whether individuals, or bodies corporate, or both, whose shares are proposed to be offered to the public, shall collectively authorize the company to take all actions in respect of offer of sale, on their behalf, and they shall reimburse the company all expenses incurred by it on this matter. The securities shall be issued only in dematerialized form, by every company making public offer, and such other prescribed class of companies. Such securities must comply the provisions of the Depositories Act, 1996 and the regulations made thereunder.
Sir, what about unlisted companies?
In case of prescribed class of unlisted companies, the securities shall be held, or transferred, only in dematerialized form, in the manner laid down in the Depositories Act, 1996, and the regulations made thereunder.
Is there any provisions of company except those companies?
Any other company except those companies convert its securities into dematerialized form, or issue its securities in physical form, in accordance with the provisions of Companies Act 2013, or issue its securities in dematerialized form, in accordance with the provisions of the Depositories Act, 1996, and the regulations made thereunder. Section 31 states that shelf prospectus is a prospectus, in respect of which securities, or class of securities, included therein are issued for a subscription over a certain period without issue of further prospectus. Also, the validity of shelf prospectus is 1 year. A company filling shelf prospectus shall be required to file an information memorandum containing all material facts relating to, first, new charge created, second, changes in financial position of the company occurred between the first issue and subsequent issue, and such other changes as may be prescribed.
Okay, Sir G.
Section 32 states that red herring prospectus is a prospectus which does not include complete information of the price of the security included therein. Also, a company proposes to issue red herring prospectus shall file it with the registrar at least 3 days prior to the opening of subscription list. A red herring prospectus carry the same right as are applicable to prospectus. Upon the closing of the offer of securities under this section, the prospectus, stating therein the total capital raised, whether by way of debt or share capital, and the closing price of the securities, and any other details as are not included in the red herring prospectus, shall be filed with the registrar and the Securities and Exchange Board. Is everything clear about the types of prospectus?
Yes, Sir G.
Now, let's talk about punishment for fraud, but before that, my question is from you. What do you think? What are the punishment if a person do any fraudulent act?
Sir G, I think he shall be liable for a fine, and also for imprisonment as may be prescribed.
Yes, you are right. We shall read this section in 3 categories. First, if a person who is found to be guilty of fraud involving an amount of less than rupee 10 lakhs or 1% of turnover, whichever is less, shall be punishable with imprisonment up to 5 years and shall also be liable for a fine up to rupees 50 lakhs. Second, if the amount of fraud is equal to or more than rupees 10 lakhs or 1% of turnover of the company, whichever is less than, the person shall be punishable with imprisonment which shall not be less than 6 months but which may extend to 10 years, and shall be liable for a fine which shall not be less than the amount involved in fraud but which may extend to 3 times the amount involved in the fraud, provided also, if the fraud involved public interest, then the terms of imprisonment shall not be less than 3 years but which may extend to 10 years, and shall be liable for a fine which shall not be less than the amount involved in fraud, but which may extend to 3 times the amount involved in the fraud. Is everything clear?
Yes, Sir G.
Misstatement in prospectus deals with 2 types of liability. First, criminal liability, and second, civil liability. Now let's talk about criminal liability under Section 34. It states that if a prospectus include any statements which is misleading or omissions of any matter in the prospectus is misleading, then every person who has authorized the issue of such prospectus shall be liable under Section 447, which we already discussed, provided that no person shall be liable if he had reasonable ground to believe that the statement was true and he continued to believe that the statement was true and omission was necessary.
Okay, Sir G.
Now comes when the second type of liability, which is civil liability, mentioned under Section 35, which states that if a prospectus include any statements which is misleading or omissions of any matter in the prospectus is misleading, and if any person subscribe the securities sustain any loss, then 1. The company. 2. Every person who is director of the company at the time of issue of such prospectus. 3. Every person who has agreed to become a director of the company either immediately or after an interval of time. 4. Every person who is promoter of the company. 5. Every person who has authorized the issue of such prospectus. And 6. Every person who is an expert shall be liable for 1. Payment of compensation to every person who has sustained any loss or damage. 2. Punishment for fraudulently inducing any person to invest money under Section 36, provided that no person shall be liable under Section 35 if he proves that, having consented to become a director of the company, he withdrew his consent before the issue of the prospectus and that it was issued without his authority or consent. Also, no person shall be liable under Section 35 if he proves that the prospectus was issued without his consent and that on becoming aware of its issue, he forthwith gave a reasonable public notice that it was issued without his knowledge or consent. Any person who either knowingly or recklessly makes any statement which is false or misleading, or deliberately conceals any material facts to induce another person to enter into it, any agreement for acquiring, disposing of, subscribing for, or underwriting securities, or the pretended purpose of, which is to secure a profit to any of the parties from the yield of securities, or with a view to obtaining credit facilities from any bank or financial institution, shall be liable for action under Section 447. A suit may be filed, or any other action may be taken, under Section 34, or Section 35, or Section 36, by any person, group of persons, or any association of persons, affected by any misleading statement, or the inclusion, or omission of any matter in the prospectus. Now we shall read about the concept of allotment of securities by a company. It states that where a company makes an offer to the public for subscription of its securities, no allotment of any securities shall be made unless the following 2 conditions are satisfied. First, the amount stated in the prospectus as the minimum subscription is subscribed. Second, the sum payable on application in respect of minimum subscription, which is 5% of the nominal amount of securities, is received by the company, or such other percentage as may be classified by Securities of Exchange Board of India, if both the conditions are satisfied within a period of 30 days of issue of prospectus, or such other period as may be specified by SEBI, shall file with the registrar a written of allotment in such a manner as may be prescribed. But if both the conditions mentioned above are not satisfied within a period of 30 days, or such other period as may be specified by SEBI, then according to Rule 11 of the Companies Rule Act 2014, the company shall repay all the money received within a period of 15 days from the closure of the issue.
Sir, what if such money isn't repaid?
If such money is not so repaid within such period, then the director of the company are severally be liable to repay all the money along with the interest at the rate of 15% per annum. Every company making public offer shall, before making such offer, make an application to one or more recognized stock exchange and obtain permission for the securities to be dealt with in such stock exchange. Where a prospectus states that an application has been made, such prospectus shall also state the name or names of the stock exchange in which the securities shall be dealt with. All monies received on application from the public for subscription to the securities shall be kept in a separate bank account in a scheduled bank, and shall not be utilized for any purpose other than for adjustment against the allotment of securities, where the securities have been permitted to be dealt with in the stock exchange, specified in the prospectus, or for the repayment of monies, within the time specified by the Securities and Exchange Board, received from applicants, in pursuance of the prospectus, where the company is for any other reason unable to allot securities, then it shall be liable to repay all the application money received. Also, a company may pay commission to a person in connection with the subscription to its securities, whether absolute or conditional, subject to the condition that, first, the payment of such commission shall be authorized in the company article of association. Second, the commission may be paid out of proceeds of the issue, or ZTHE profits of the company. Third, the rate of commission in case of shares shall not exceed 5% of the price at which the share are issued, or a rate authorized by the articles whichever is less. And, in case of debenture, the rate of commission shall not exceed 2.5% of the price at which the debenture are issued, or, as specified in the company's article, whichever is less. No such commission shall be paid if the securities are not offered to public.
Sir G, what if company defaults?
If a default is made, in complying with the provisions of this section, the company shall be punishable with a fine which shall not be less than 5 lakh rupees, but which may extend to 50 lakh rupees, and every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 1 year, or with fine which shall not be less than 50,000 rupees, but which may extend to 3 lakh rupees, or with both. States that a company, whether it is public or private, can issue securities through private placement, subject to the conditions that a private placement shall be made only to the selected group of person who is identified by board, whose number shall not exceed 50, or such higher number as may be prescribed, excluding the qualified institutional buyer, and employees of the company being offered securities under a ESOP scheme. However, a company can issue securities to 200 persons. In the financial year, a company making private placement shall issue private placement offer in such form and manner as may be prescribed. No fresh offer under this section shall be made unless the allotment, with respect to any offer made earlier, have been completed, or has been withdrawn by the company if the company enters into an agreement to allot securities to more than maximum number of persons prescribed, then the offer shall be deemed as public offer. In such a case, the company shall have to comply with the provision of the Company Act 2013. A company shall not make a private placement of its securities unless such proposal has been previously approved by the shareholders of the company by passing special resolutions. However, in case of offer for non-convertible debentures, it shall be sufficient if the company passes special resolution once in a year for all the offer or invitation for such debentures during the year. Also, a company making an offer under this section shall allot securities within a period of 60 days from the date of receipt of application money for such securities.
Sir, what is company defaults?
If the company is not able to allot the securities within that period, it shall repay the application money within 15 days from the expiry of 60 days, and, if the company fails to repay the application money within a freeze period, it shall be liable to repay that money with interest, at the rate of 12% per annum, from the expiry of 60 days, if a company defaults in filling the return of allotment within the given period, then the company and its promoter and director shall be liable for penalty of 1,000 Rs each day till defaults continues, but not exceeding Rs 25,000.